part 4 or 5, who knows?
Behavior that would lead in that direction. Stick solely to the complaint, please.
Sorry, Mr. Chairman. And fourth, I believe that legislators have a heightened responsibility to demonstrate heightened, information literacy skills. I think there's a lot of information out in the world, and we have a responsibility to know when we need to find it, know how to find it, know whether it is valid, how to consume it, and then how and whether to share it. And I think for people in positions of power and public influence, sharing blog posts in which an author has not fact-checked certain claims doesn't meet my personal standard of basic information literacy. And I think by doing that, we perpetuate the idea that anything we see on the internet is news. And to be frank, I think if we all did that, if we all shared everything we saw on the internet and even implied that it was, quote, news, I think, to be frank, that would make us all look like idiots. And I think that has the effect of reducing the perceived integrity of this body. So those were my opinions.
Thank you, Representative. And going back to your first reason, you mentioned a daily oath. Can you elaborate on that a little bit?
Yes, every morning we take the pledge. I don't think I need to recite it, though I'd be happy to. But the pledge concludes with liberty and justice for all.
Thank you. And so you referenced Representative Giddings' social media activity. Are you familiar with Representative Giddings' Facebook page contents as it relates to the Von Ellinger hearing?
Yes.
And if you would turn in your binder to Exhibit 4, which is in Exhibit 3 for the committee. And if you would turn several pages to the posting from April 16th. And let me know when you're there.
I'm there.
Is this consistent except redacted from what you witnessed on Representative Giddings' Facebook page?
It seems so, yes.
And so when you access Representative Giddings' Facebook page, the Jane Doe from the Von Ellinger hearing, her picture was visible from her page, is that correct?
Indeed.
And do you believe that that content is appropriate for a member of the House of Representatives to post on Facebook?
Negative.
And why is that?
For multiple reasons. One, anyone who is familiar with our criminal justice system, I have a degree in criminal justice, knows that victims of sexual assault are usually given the least amount of justice and fairness in our system, and I think many of us are committed to trying to remedy that, take steps to remedy that. One of the things that we can do, and that many of us do, is protect the identity of people who come forward to report allegations of sexual assault. I don't distinguish between making initial public revelations of identity from disseminating further that identity. The second reason is that, assuming for a moment that sharing that information was legitimate, which I don't think it was, to add declaratory statements of opinion to the dissemination would suggest that conclusions have been drawn about the validity of Jane Doe's claims, and as I mentioned earlier, legislators were privy to a comprehensive set of information prior and during the Von Ellinger hearing, including all of the transcripts from all of the investigations, and no one who did their due diligence could have concluded that Jane Doe's claim was baseless.
Understood. And so, Representative, is it fair to say that part of your concern with the social media posting was not just the posting itself, but perhaps the amplification of that information, the dissemination of that information?
I believe so, but I'll just be frank. I have concerns that when we say things on the internet that directly cause harm to others, that's not protected free speech, and I don't think we should engage in that kind of speech.
Are you familiar with Representative Giddings' testimony during the Von Ellinger matter?
Not word for word, but generally speaking, yes.
In your understanding of her testimony, do you believe she was forthright?
Define forthright.
Do you believe that she was giving testimony consistent with the witness oath, to tell the truth, the whole truth, and nothing but the truth?
The truth, perhaps. Nothing but the truth, perhaps, but the whole truth, no.
So you don't believe she was telling the whole truth during her testimony?
I do not.
And why do you think that?
Because in response to extremely straightforward questions, Representative Giddings suggested that she was either unable to answer the question or did not recall whether she was the person or not who posted that information.
Thank you. And could you describe for us a bit of your understanding of the standard of conduct that's required of a member of the House?
Yeah, the standard of conduct for members of the House is, it's difficult. For those who are trained lawyers, beyond a reasonable doubt is a relatively straightforward standard with plenty of case law to help reason through that. Same with preponderance of the evidence, but conduct unbecoming is not. So in my interpretation, conduct unbecoming is conduct that if every legislator did it, it would lead the public to frown upon the body as a whole. And I think that if every legislator publicly cast doubt on the claims and defamed people who report sexual assault, I think that it would do a number of things. One, it would create an environment in which Idahoans, particularly our most vulnerable Idahoans, are less likely to report claims of violence or violent crimes or claims of sexual assault. And I also think that when we do that, we create an environment where the court of public opinion gets to a point where it has an undue impact and influence on the investigative process, the adjudicative process. And I don't think, particularly in instances of allegations of sexual assault, having the public weigh in as to who's guilty or not while these things are still unfolding, it does not promote justice.
And so, to summarize, do you believe that Representative Giddings' conduct in connection with the Von Ellinger matter is consistent with the standard of conduct you believe is necessary for members of the House?
Not at all.
And no further questions at this time. Chairman Dixon, I'll turn the witness over to the committee.
Thank you, Mr. McCurdy. Committee, any questions? Representative Mathias. Representative Warren.
Thank you, Mr. Chairman. Representative, are you aware of any other member of the Idaho legislature that posted the name and identity of the alleged victim?
I am not.
Thank you.
Representative Craig.
Thank you, Mr. Chairman and Representative Mathias. We talked about this a little bit when you came before the committee in the preliminary hearing. But now that we're in full public hearing, I know that there was question and answer back and forth between you and I regarding the First Amendment and restricting or curtailing a legislator's right to that First Amendment. So I'm sure you've done as I have done, went away from that preliminary hearing and done some thinking about our conversation, our discussion back and forth. I think if I can remember correctly, back to the 28th of June when you came in, your concern was, or you felt like the line should be drawn, that public officials should not be allowed to post stuff on social media if there was a pending trial or the case was still under investigation. Is that correct as far as you recall that conversation back and forth between you and I?
Representative Crane, I don't recall making that statement because I'm not sure I agree that while investigations are underway or, court proceedings are underway, that legislators or public officials shouldn't be allowed to post to social media. So if I said that, I don't agree with that today.
Okay, so you've had some time to rethink that position. So it's your belief that we should not curtail legislators' First Amendment rights then?
So long as though, and I assume we're talking about speech, which is one of the First Amendment rights, and I also assume that we're talking about protected speech, not unprotected speech.
Mr. Chairman? Just, the discussion you had with the committee, and I was the one asking the questions at that time with the committee, was around this issue of First Amendment rights and what is afforded to a lawmaker and what's not. And I've got it here in front of me, my questions and your response, but it seemed like at that point, you were concerned, because I'm struggling with this issue of, should we restrict a legislator's First Amendment rights? And at that point, you seem to say, yeah, I think that we should, and it's gotta be instances of public safety. Do you recall that?
I do.
Okay, so are you still in that same frame of mind, that there are restrictions that's placed on legislators, their First Amendment rights, or there's just consequences if you say something publicly you shouldn't?
Representative Crane, thank you for that clarification. I do agree, still, I do believe that legislators should be subjected to the same constitutional protections that members of the American public are. And one of those, and I believe it was Representative Cheney that mentioned this earlier, is that we are free to speak, but not when our speech brings direct harm to others. And in this instance, I think a reasonable person can conclude that Facebook post from April 16th directly harmed Jane Doe and is therefore not protected speech and therefore suppressive.
Well, Mr. Chairman. Thank you, Mr. Chairman and Representative. So, as a committee, as we try to work through this issue of free speech and where do you draw that line and what's appropriate, what's not appropriate, what predictability members can have as they operate inside this body, where do you feel like that line should be drawn with respect to the First Amendment right of a legislator, because they're still a citizen, and yet not harming individuals in that process?
Representative Crane, I think all adults, whether they are legislators or not, always need to ask themselves before they speak publicly, whether online or in a public forum, they always need to ask themselves, is what I am about to say going to bring direct harm to someone else? And if the answer is yes, then that person has a responsibility to second guess themselves and reconsider whether they should say what they are about to say. I think because we are legislators, we have a heightened responsibility to pump the brakes on things that might lead to that outcome. And for that reason, I think the Facebook post from April 16th violated that standard of care.
Have you ever posted something on social media that you later regretted and withdrew that post or took that post down or issued a public apology? I have taken posts down. In fact, I consider it a great specialty of mine to draft tweets and delete them before hitting post. But I've never said anything for which I felt compelled to apologize. On those posts that you have pulled down or tweets that you have deleted, would that make a difference for you in this case with Representative Giddings? Had she removed that post from social media, or had she made a public apology and said, you know what, wisdom is I should never have posted that in the first place? Would that have caused you to pull back and not move forward with this complaint?
I suspect that if that, I'm looking at it, it was posted on April 16th at 9:43 p.m. If it would have been posted and then taken down within minutes before it could have caused harm to Jane Doe, then yes, I think that is a side. Unfortunately, but similar circumstance where we say something we shouldn't have and we delete it. But I think the main distinction is that the speech led to someone's harm, and before it could be removed, the harm occurred.
Understand that we're all human beings, and we do make mistakes, and I have made mistakes inside this process and had wise senior members pull me aside and say, have you thought about what you said? Or I can still clearly recall a time I said something that was factually true. I was correct, but it hurt an individual. The next time we were together as a group, that individual said, what you said hurt me. And at that point I had an obligation. I could either apologize or I could double down because my facts were right. And I chose to apologize and restore the relationship and humble myself. So do you think that that same grace should be afforded to individuals inside this process? Because we are human. We are going to say things, whether it's in committee, on the floor, on social media, that maybe when a wise senior member pulls us aside and said, have you thought about the impact, that it could be corrected? So do you think that grace should be afforded to someone to pull something down or retract a statement or walk something back and not have to move forward with the hearing as we are today?
Representative Crane, do I think the grace should be afforded to a hypothetical citizen? Sure. But this is not a hypothetical. What we are talking about here is on the one hand, the speaker, and I don't mean the House Speaker, I mean the person making the speech, having a heightened responsibility to be careful. And we also have someone on the receiving end who wasn't just hurt, but I think a court could find that they were harmed demonstrably. And I think when you add in those two variables to the hypothetical, that it would lead me to conclude that no, I don't think grace is something that can be given in lieu of accountability in this instance.
Okay.
Representative Gannon. Thank you, Mr. Chairman. And Representative Thias, an intern who works at the legislature also has a right of free speech, doesn't she?
She does.
And in exercising that right of free speech, it can be very difficult and intimidating, especially if she were to exercise it in regard to somebody who was in authority, don't you think?
Could you restate the question?
An intern, a teenage intern, 19-year-old intern who exercises her right of free speech to a person in authority would certainly, it's certainly an intimidating thing for a young woman like that in that situation to exercise her free speech and make a complaint against another person who is in authority, another legislator.
Yes. I can see how that would be difficult, yes.
And is that one of the reasons that we have policies and laws in place to protect whistleblowers and those who are in public employment situations from retaliation, from adverse action by those who are in a position of authority?
Yes.
And you heard Representative Waddy's initial testimony that not only in public employment, but he felt throughout many employment situations outside of public employment, there was this same policy of protecting persons' identity, so that people would feel free to come forward and make legitimate complaints.
I agree, though I would add, and similar to some of my responses to Representative Crane, we're not talking about everyone, and we're not talking about all policies and all interns. We're talking about someone who alleged a particular type of crime. And I say particular because those of us familiar with the criminal justice system know that unlike people who report murders, unlike people who report being mugged or robbed, that people who report being sexually assaulted are for some reason subject to heightened public suspicion. Even though the best available peer-reviewed evidence and research suggests that false claims of sexual assault are almost never made. So, to answer your question, yes, those policies and rules apply for those reasons, but I believe as a legislator, I believe all legislators have a duty to A, recognize what I just mentioned about this particular subset of people who report crimes, and secondly, take proactive steps, or in this case, be restrained from subjecting them to undue harm when we already know, as you mentioned, that doing what they do is extremely difficult and occasionally dangerous.
And Representative Mathias, you worked for this state board education for a number of years.
Correct.
And did you work in other public employment?
Yes, I've been an intern at the Idaho Supreme Court. I served in the United States Coast Guard. I also worked for the United States Senate, the University of California, and Boise State University.
And in connection with your employment in those positions, are you familiar with the personnel policies when you were working there?
My more recent employment stints, yes.
And if an intern, for example, had reported to the State Board of Education that she was sexually harassed, even a more serious matter, and by a person in authority, and another person in authority at the State Board of Education, maybe a member of the board, posted information on social media such as was posted in this case, would there be a consequence for that person who posted that information?
Yes, in my experience working in Idaho state government, that person would most likely, at minimum, have that conduct reflected in their personnel record, and it would likely bear weight during their annual performance evaluation, yes.
Thank you.
Any other questions for Representative Mathias? All right, Representative, if you would give us 5 minutes, remain there while we allow Representative Giddings the opportunity to come cross-examine you. We will take those 5 minutes.